From the main list, item number 1.
May it please your lordship, I am appearing for petitioner, my lord. As per last order, my lord, state was supposed to, my lord, apprehend, my lord, a kingpin behind the, my lord, entire 13/3. Your lordship may kindly see 13/3/2020.
Yes, where are we, Mr. Khan?
Lordship, if I may take, there is an order 13/3/2023, Lordship.
Yes, if you look at the main substantial paragraph, the final substantial paragraph,
Lordship.
your submission, Advocate General submission that the state has called upon investigate to trace out the original operators, bring them to book. Where are we?
Lordship, first, if you come to the para 2, Lordship, 2 and 4, if you come to the interim report, Lordship, 12th interim report, Justice Kakati's report, Lordship. We have addressed this issue in para B. If you come to B, Lordship, B3
Of the interim report.
12th interim report.
Yes. What does it say? It's not with us immediately, tell us. No, it's part of a different matter.
Oh, sorry, Lordship.
It's not part of this matter.
So, Lordship, B is status of closure of illegal coke oven plants.
Yes.
Lordship, 57 coke oven plants in West Khasi.
So we take it that the state has done nothing.
Lordship, we have shut down, Lordship. This is a report of Kakati's report.
Please come to our order of 13th of March.
Lordship.
The substantial final paragraph.
Lordship.
Learned Advocate General submits that the state has called upon the investigating agency to trace out the original operators and bring them to book.
Lordship.
What has the state done?
Lordship, 310, Lordship.
Yes.
310. The Secretary, Mining and Geology Department, Government of Meghalaya has informed that the Deputy Commissioner of West Khasi Hills District has issued notice on 9/3/2023 to 4 coke oven plants, namely Rialang, Karbachem.
You probably don't follow us. Either you are trying not to or you don't.
Lordship, I just allow me.
No, sir. We've had enough of this nonsense going on. The state made a statement, we'll get to the kingpins. What has the state done? We're not interested in coke mines being shut down. Where are the perpetrators? Why are they not in chains?
Lordship is correct. But Lordship, kindly allow me to just clarify on this issue.
We are not interested in your dodging. Where are these people? Your Advocate General made a statement.
Lordship.
Where are these people? What has the state done?
Lordship, kindly just allow me to clarify. We understand the seriousness of the query, Lordship, but kindly just allow me to clarify on this issue, Lordship.
We are not interested in coke plants being shut down. That's a different matter.
Lordship,
that's happening in the usual course. Where are these?
Lordship, kindly just allow me to address this, and then we'll try to attempt to clarify, Lordship. Lordship, in 310, the notice was issued to these coke plants. The important word used is, Lordship, which has not submitted any documents relating to source of the raw material. So, Lordship, will kindly appreciate what has fallen from your Lordship is the second question that needs to be answered. As per the inquiry report, we have submitted that we have issued notice for them to first disclose where is the source of the materials. Now, if your Lordship will, can you allow me to read, which have submitted any documents relating to source of raw materials, i.e. coke, to furnish same or to face closure notice, including seizure of coal and coke. Out of the aforesaid 4 coke plants appointed by Deputy Commissioner, West Khasiel District, so-and-so coke plants have in the meantime been closed down on the ground of not having certificate to operate, renewed by Meghalaya State Pollution Control Board. Likewise, the Deputy Commissioner E. Jayantya Hills has issued notice on 29 to all these plants which have not submitted documents in support of, Lordship, I emphasize on the word source of coal, giving warning that in the event of failure to do so, industries would be closed down and the coal would be seized. Lordship, kindly appreciate, if you allow me to submit, Lordship, the state has taken first step, and this they have informed the Kakati report that these are the coal operators who were operating and asking them. 57 has been shut down. Kakati report clearly says this, Lordship. The second part of the query, with the Learned Advocate General made a statement, Lordship. If I may humbly submit, Lordship, we are in stage 1, asking them to disclose. No, Lordship, kindly appreciate. The moment they do not disclose, or there is no material, Lordship, the second step would be, then the state will be held, Lordship, if they don't close down. Or if they disclose, Lordship, the source, then the onus will be on the police or in the state to do for further investigation that the source disclosed was correct or not. So, Lordship, we completely agree with what has fallen from your Lordship. But Lordship will kindly appreciate that.
Going to a
Lordship will kindly appreciate we are in
going
stage
to a
1.
petty thief and asking him, please tell me which of the houses have you burgled and what are the material that you have burgled.
Lordship will kindly appreciate.
There are 2 things. One is this illegal operation,
Lordship.
which continued with your support for all this time. It was only upon PILs coming up that they were closed. It is inconceivable that coke plants could have operated without everyone knowing it. So when you were cornered with all this material, you stopped the coke plants. The categorical submission was that most people have abandoned and run away now that the state has to take steps because of High Court order. So it was, who were these people who were your protected? And you have done nothing to go after them.
Lordship, as I submit, we are not denying it.
And your Advocate General has made a grandiose statement and left you holding the baby.
Your Lordship, we relying on the Kakati report, Your Lordship, and Lordship will kindly appreciate.
The two are completely different.
Absolutely correct, Lordship. We are not denying it, Your Lordship. But the fact remains, Your Lordship, after the court has seized the matter in a PIL, Lordship will kindly appreciate it's a non-adversarial proceedings where we don't have anything to argue, Your Lordship, other than to see compliance report. Now,
the immediate previous order on this matter recorded a submission by Advocate General for the state as would be evident from the penultimate paragraph of such order, set out paragraph. Mr. Khan, Learned Additional Advocate General, refers to Justice B.P. Katake's 12th interim report and several paragraphs therefrom to indicate how coke plants operating illegally and without any permission have been shut down. Full stop. Council emphasizes that 57 illegally operating coke plants have been shut down and steps are being taken against the rest who cannot indicate permission to operate or explain the source of obtaining coal for their operations. Full stop. Paragraph. Repeated orders of this court have pointed out that the present situation where illegal coal mining continued blatantly from 2016 despite orders of the National Green Tribunal and the Supreme Court, no less, prohibiting them, with the tacit support of the state. Full stop. Despite the state and its chief secretary being tasked with the obligation to ensure that illegal coal mines did not operate, the industry boomed till so much cognizance was taken of the matter by the state, by this court, and some form of regulation or control may now be in place. Full stop. It took public-spirited citizens to bring to the notice of this court that illegal coke plants had mushroomed all over the place without either the state making any effort to ascertain the source of coal used thereat, or to check whether such plants had permission to operate. Full stop. Paragraph. Again, after being goaded by this court, the state now gloats in its glorious action taken to shut down the illegal coke plants that should never have sprung up in the first place. Full stop. As to the kingpins, who had obviously been nurtured and protected by the state to run such illegal industry, the state has done absolutely nothing. Full stop. When queried by the court, counsel insists on the steps taken to shut down the illegal plants without so much as a word as to the persons who operated them and acted in flagrant disregard of orders of the Supreme Court. Full stop. Paragraph. The state is now announcing with a lot of fanfare about the imminent commencement of scientific coal mining. Full stop. However, due to the callousness of the state and its criminal support to persons who indulged in rampant illegal coal mining, valuable revenue has been lost, several lives have been sacrificed in rat hole mining, and illegal transportation of coke has continued unabated, so much so that the court was pushed into seeking central assistance to stop the illegal transportation of coal within the state. Full stop. In another matter, paragraph. In another matter, it has been discovered that a single entity in various avatars has exported thousands of metric tons of coal through the Gaswapara land customs station without anyone, whether from the state or at the relevant LCS, seeking to ascertain the source of such coal. Full stop. Indeed, there is even an FIR filed by the sales tax authorities in Guwahati to the effect that the coal may have been of Meghalaya origin and may have been shown in the papers to have been transported from Guwahati or thereabouts back to Meghalaya for export without such coal moving any place other than ultimately to Bangladesh. Full stop. Paragraph. These are matters of serious concern. Full stop. Despite repeated orders of this court, the state has cared little to check the menace, though the state was always encouraged by the court to ensure that scientific coal mining was started, so that the cottage industry of illegal mining would be stopped. Full stop. Paragraph. The matter will appear 4 weeks hence for the state to indicate the persons behind the illegal coal plants that had been set up and the steps taken in accordance with law to bring them to book. Full stop. Paragraph. Justice Katake will, doubtless, ensure that the illegal coke plants are no longer in operation by the time the matter appears next.
May I pray your lordship?
Yes.
If your lordship may refer the matter to CBI for so far as investigation part is concerned. Because state is doing nothing, my lord, so far as FIR, as per last order.
Lordship, if I may just submit the order of 13/3/2023, the fourth paragraph, Lordship. Accordingly, the petitioner is given liberty, my friend on the other side, to approach Justice Kakati, who has been appointed to monitor the implementation of orders to illegal coal mining in the state, to ensure that similar illegality is not perpetuated by illegally operating coke plants. The liberty was granted on 13/3, Lordship. 3.6 of the Kakati's report, Your Lordship. Just allow me to just read out, Your Lordship. It may be mentioned that though White Order dated 13/3/2003 passed by this Honorable Court in PIL number so-and-so, liberty to approach the undersigned was given to the petitioners in the matter of illegal operating coke oven plants. Neither the petitioner nor the representative so far has made any representation.
My lord, this
was in the order is passed. Please come back after 4 weeks if you want to.
Lordship, my only apprehension, Lordship, is this: what has fallen from the court. If they can file a representation or to bring in some facts,
nothing is necessary, and we are stopping short of calling it a rogue state. But don't push us.
Lordship, my duty was just to point out.
Don't push us.
If anything comes to the knowledge of petitioner, they can bring it to the knowledge of regarding illegal.
First, you do what you have to do. We'll find faults with the petitioner.
No, we're not finding fault, Your Lordship. In case they do it.
That's what we've given them more time. Just indicate that.
Lordship, the petitioner is a public-spirited person. Even they can assist. We are not denying, Your Lordship, that something bad is.
We don't want the petitioner to interfere too much. The petitioner is like an informant in a PIL. After that, we take over.
Oblige, Your Lordship. My duty is just to point out.
Yes.
Item number 2.
Lordship, the same Kakati report is.
This language is reprinted in newspapers. People just don't care. I would have dug a hole and gone into that if something like this was written about me.
Same order can be passed in next matter.
Very well. In view of the order passed in the similar matter in PIL number so-and-so earlier today, let this matter appear 4 weeks hence, immediately after the other matter. Why is the advocate general not here? He had indicated. From day one, he's been smiling and saying, yes, we're doing 3 bags full, sir.
Lordship will recollect in the last occasion I had submitted that the special court has been appointed, the authority has been appointed. Not for a moment I'm saying, Lordship, that what has happened, we are
You are
condoning
the
it.
persons. You also have leads in Jaimata. You are the state.
Lordship is correct.
You can't find out who are the people who are financing them.
So I've sent a petition.
Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
This is the Greenfield Airport matter. I think
Airport, we've left it to them. What is happening, Mr. Khan?
Lordship, we just had as per instruction received,
Yes,
there was an informal meeting
yes.
between the airport and the government. The issue was regarding identification of the land.
Regarding?
Identification of the land, Your Lordship.
Yes.
That was a detailed order on 28 March passed by the Honorable Court. So, Lordship, to my best of my knowledge and information received, the informal decision has to be formal with expert bodies. So that, Lordship, my friend also can
Yes,
help us
because
out.
that we've indicated that
sure.
here is something that we can't push.
Absolutely. It is indicated in order.
We hope that you do it.
Yeah, absolutely, Lordship.
But-
It is falling from the court. We'll have to take care of it, Lordship.
This is something we can. Any progress, any likelihood? No,
As of now, it doesn't appear.
doesn't appear.
But as stated, Lordship,
What is stopping it?
Lordship, we are making an endeavor. So we should be coming with some positive report in next 6 weeks, at least so for identification of the land. Whether it's feasible, it's working out, experts will be required. And of expansion. Of
The
expansion.
current approach, my lord, as indicated in the last order, they should just survey the areas, my lord, without much publicizing it, and see if any feasibility, then they can
So Lordship, we are working on that.
go for further.
Very well. In view of the previous order of March 28, 2023 and the observations made therein, there is little for the court to do in the matter except to exhort both the state and the union to look at the possibility of enhanced airport facilities servicing the state so that the road travel time from Guwahati is eliminated and a bigger airport in the state, close to Shillong, acts as an impetus for further development in the state. Paragraph, both the state and the union report that they have held meetings and are taking steps, but nothing concrete has come off yet. Full stop. Paragraph, let the matter appear 3 months hence to ascertain whether there is any progress in such regard. Full stop, give it a date.
Item number 2.
Mr. Dr. Monika, your airport director is here. If you talk to him privately, you will find out that there are possibilities. And you can't say he is not an expert.
I'll try to extract that well.
Because here we need something where, your state needs it. An independent airport adds to the prestige of the state, gives it a lot of push. Gives it a lot of push. Because every footfall adds revenue.
Absolutely.
Every footfall adds revenue.
I'll try to find out.
And here, I hope all of us work for the state. It's not nothing personal, but work for the state. It does not behove a state like Meghalaya. We are not in the, even Paro has a good airport. We are not in the, mid-Himalayan range. We are foothills of Garo Khasi and Jaintia. Something can be found where, we can boast of our own.
I believe traffic has increased now.
Traffic has increased tremendously. There are 5 or 6 flights
Or day,
to Imphal, Dimapur, Aizawl, Kolkata, and now to Delhi. On 5 days a week. But with a little bit of adjustment, maybe you don't get A380. We're not interested. But A319 may still be possible. Yes.
Hello. Lordship, consequence to this Honourable Court's direction.
Yes, what is this matter, Mr.
This is a matter regarding the football field. And
Private ground.
Yes.
Lordship desired to get some maps or whatever is there to show where is this Swiss cottage.
Yes.
Where it is lying across it. We have submitted an affidavit just yesterday, Lordship.
We have also received only yesterday, my lord.
Very well. Since an affidavit has been filed by, you're for the state.
No, Your Lordship, I'm the appellant.
Oh, for the appellant. Since an affidavit has been filed by the appellant recently, the state may deal with the same by using a rejoinder, full stop. The rejoinder, if any, should be filed within a week. The matter will appear 10 days hence.
Not the state, it's the private respondent.
4 and 5.
Very well.
4 and 5.
The state and the private respondent. We will give the respondents.
Obliged.
Everyone is free if you want to use it.
Yeah. Much obliged.
Item
Thank
number
you.
3.
This is that minimum guarantee.
No, my lord. This NTPC matter, where NTPC and MECL have been attempting to discuss and resolve that issue.
Yes.
CERC order was put under challenge.
Yes.
So, limited instruction for today, my lord, is that discussions are still ongoing. Several more rounds have been held, but finality has not yet been obtained.
Very good. When do you want us to keep it?
About 3 weeks at least, my lord.
Very well. We'll give you more time if you want.
Obliged, my lord.
Since it is submitted, particularly by the respondent, that several rounds of negotiations have been held and some more time is necessary, let the matter appear 4 weeks hence.
Obliged. Grateful, my lord.
Item number from the main list. Item number 1.
Yes.
But this is a matter where there were certain errors while publication in the Gazette, my lord, and those errors were sought to be rectified by a corrigendum, my lord. And that corrigendum, without following the due process of law, has been recalled by the District Council, my lord.
Corrigendum published and recalled by the?
Recalled by an executive action, my lord.
What is this?
A certain bill was passed, my lord.
Bill was passed.
And at the time of publication in the Gazette, some errors crept in, my lord. And this was simply in my humble submission, it's a typing error, my lord, or publication error. And that then district council wrote to the government, there was certain errors in the publication of the gazette. So state government issued a corrigendum in the gazette saying that certain words should be there.
And now the corrigendum was in agreement with the enactment that was passed.
My lord.
And then they withdrew the corrigendum.
District council by an executive order.
District council withdrew the corrigendum. Why the state had published the notification?
The law was passed by district council under its authority under section.
The state endorsed it.
State endorsed it because
and
gazette is published by the state, my lord, by the district council affairs department.
So again, if you want to change it or if you want to alter it, the district council has to go to the state for the state to notify.
First, district council has to carry out a legislative process, my lord, for amending, and then go back to state for publication of the amended provision, my lord.
Yes, so without going into the merits, Mr. Quinta,
Lordship,
the process appears to be wrong.
The last occasion, your lordship was desirous of knowing what was the original bill, what was the original proposal. So, as I have indicated to this court that this is a codification from the part of the legislative process of district council. The original proposal made by the same of Millian, I have submitted before the court, and I have submitted a copy each. That is the original proposal. Original proposal shows that Nongklau Ringi is there. But subsequently during the course when it went from the legislative wing to the government, there that the term Ringi disappeared. That's how this all issues have cropped in. We need to correct that, your lordship.
So you are agreeing with the appellant?
Whatever the appellant wants, I'm not.
District council is siding with the appellant.
So therefore, and you are the other. If the matter is purely between the district council and the.
It is not.
It has to be.
It is not.
It has to be, Mr. Pal. After that, we'll hear you. Because the district council adopted a resolution for a particular rule or law.
Lordship.
The district council has to accordingly inform the state and have the state endorse it before it is gazetted. And it's only upon publication that it comes into effect. So the district council did that. Something was notified by the state. The district council found that that was erroneous. The district council wrote to the state that look, that has to be corrected. Accordingly, a corrigendum was issued. Now, upon the corrigendum being issued, matter would have been final unless there was a further mistake. Now, on what basis was the corrigendum withdrawn? Did the district council call upon the state to withdraw it?
District council called upon the state to withdraw it, Ballard?
District council called upon the state to withdraw it.
Thereafter, the state published it in the official gazette, withdrawing that corrigendum.
Now, there has to be justification as to why the district council called for it to be withdrawn. Now, that, according to Mr. Quinta, is that what was originally proposed by the same of William agrees with what was ultimately published, original publication plus corrigendum.
Which is where I come in, Millers. The same of William is a party before your lordships in these proceedings.
Yes.
Same of William categorically says, Millers, that the original publication without the corrigendum is the correct position. You cannot have a position, Millers, post corrigendum.
Very good. Now, very good. Now, same of William has made a representation to the district council.
Lordships.
District council, in its wisdom, passes it with or without modification. The district council is the authority.
In my humble submission, Millers, what we are concerned here with is the the electoral college of the Dorbar of the CMO Millers.
But it's a district council which has authority over it.
Millers, which is why, Millers, the district council, what essentially happened, if your lordship grants me this liberty, there was this one letter which was issued post Millers, the original enactment. whereby they said the original bill is not tallying, so please make this correction in the
Mr. Pal, there is only one thing. We don't want to. We should not be going into the merits. We should not be going into the merits of the matter. That is why I am wanting to engage you. I'm wanting to engage you. Just consider this. If the collegium has been rightly or wrongly withdrawn, we can confine ourselves to that, and we leave it open for the district council and the state in consultation with the district council to take appropriate steps. And that is where you come in. You have to then ask for the appropriate steps to be taken, or ask the state not to yield to the district council's request to publish a corrigendum.
What I am humbly submitting before your lordships, that the bill as was passed by the house was without the corrigendum.
As was originally notified.
Yes. Because the notification, the corrigendum which they're talking about, it goes against the basic.
Very good, very good. Let it be.
The electoral college.
Let it be. But then the district council says that you made a mistake.
District council originally said they made a mistake. Subsequently, they said there is no mistake, so they withdraw the corrigendum.
The district council said withdraw the corrigendum?
Yes, my lords.
We had to withdraw the corrigendum not only because of this particular issue. There are other issues also, your lordship. It's just not.
The confusion has been created by the district council. Because first they say corrigendum, subsequently they say withdraw the corrigendum.
Admittedly, it's a fact that we have withdrawn the corrigendum.
Which is why I'm trying to take your lordship to the merits of the matter. The act with the corrigendum would go against the basic ethos of how the Same of Million functions with its Dorbar.
So let us see the act as passed by the district council and sent for endorsement and notification by the state.
Lordships. I had already submitted before lordships. That would be where the entire case would have to be decided by what was passed by the house.
My lord, may I point out the documents, my lord? This is the 3 or 4 documents only, my lord.
Then you have to challenge the viries. Then it's no longer the procedure of withdrawal that you have to challenge. Then you have to challenge the viries on whatever grounds which are available.
I'll point that out, my lord. My lord, Lecture 2, page 22 is the bill that was passed by the district council, my lord.
Yes.
And lordships will find at page 32, my lord.
32,
my lord.
List of electors of Milliam CM-ship.
So, my lord, the dispute is with regard to row number 5, my lord, Nongkla Ringi, Mintri.
Nongkla Ringi.
Mintri.
Designation is, the problem is with Nongkla Ringi.
My lord, only with this, my lord.
Yes.
Now, this bill was passed by the district council, my lord, and sent to the state government for publication in the Gazette, my lord. Gazette, it came by way of Gazette publication, my lord, and that starts from page 35.
Page 33K.
But page 35, my lord, this is the Gazette, my lord. And page 45 is the relevant entry, my lord.
Page 30?
The Gazette publication starts at page 35.
Yes.
And the relevant part is at page 45, my lord.
What is at page 33K?
This is a type of the previous document.
So we'll come to page 45.
Page 45, my lord. At the bottom, my lord, entry number 5, only Nongkla word came, my lord. Ringi word was left out, my lord, while publication in the Gazette. Then district council realizes this, my lord, and by page 49, my lord.
No, on fact there cannot be any dispute,
my lord. But I just want
according to Mr. Pal,
my lord,
what was gazetted was exactly which was passed by the district council.
That's not the case, my lord. My lord, that is why the earlier occasion district council wanted to produce the record, because district council is the best person to say what bill was passed, my lord.
From the district council records, what do we see? It was passed without Ringi.
With Ringi, my lord.
It was passed with Ringi.
That is our case, my lord.
And then,
Page 49, my lord.
page 49,
The district council writes to state government, my lord. Madam, with reference to subject mentioned above, I am to inform you that after comparing
Nongklo instead of Nongklo Ringi.
my lord. And after this was, with a request to correct the same, my lord.
And then it was published.
Then a corrigendum was published, page 50, my lord.
Yes, then at 14, Ringi word has been
Only
used.
after the word Nongkla, my lord. So, my lord, once this was done, the things are in place, my lord. Now what happens, my lord? By page 62, my lord. And this is an executive resolution, my lord. This has not gone through any legislative process, my lord. It says, my lord, the Executive Committee, Khasi Hills Autonomous District Council, has, after consideration of the corrigenda published in the Gazette of Meghalaya Extraordinary so-and-so, pertaining to the Khasi Hills so-and-so, has decided to recall the same with immediate effect due to procedural lapses.
Now, if you come to page 52, does not go from the district council. 52 goes from the same. $52 goes from the same.
From the same to district council, my lord.
Yes, to the district council.
My lord.
And then the district council follows it. Where is the, by which letter does the district council withdraw the, ask for the amendment? 45.
Yes, 45, my lord.
No, 45 is as it was published in the Gazette.
49, my lord, sorry.
49.
No, 49 is insertion of law.
49 is seeking corrigendum.
Seeking corrigendum, my lord.
Nongklo instead of Nongklo Ringi.
My lord. And the corrigendum issued is at page 50, my lord.
Corrigendum issued is at page 51. Then the CM writes to the thing, and the Executive Council of the Executive Committee of the District Council then takes a decision. And where is the further request to the state?
It's not been annexed.
No, you filed an affidavit, it must be happened to you.
There's an affidavit, my lord.
They filed a supplementary affidavit, bringing into the two notifications issued by the state. Supplementary affidavit dated, this is.
No, but how did the state receive the request from the
The
district
formal
council?
request from the district council. They received a formal request from the district council.
Where is that request?
I think district council will be in a better position to place that before lodgement.
Lordship, this is, when you look at page 50, the recall is because not only on one error, there are so many errors. And to close this matter, Your Lordship, I have a suggestion that we have noticed that instead of Nongkla Ringi, it's only Nongkla. In fact, it could be open for the writ petitioner to write to the executive committee to correct this either by executive order or by legislative process to bring the original Nongkla Ringi as per the original proposal of the same Millennium made in 2007. That would have closed the matter and the matter could be resolved afresh. If you are going to correct at this stage, nothing could be done, Your Lordship. There is a corrigendum, there is a withdrawal of the corrigendum, total confusion, because the mistake is not only against one particular case, Your Lordship, many other cases. When we look at page 50,
Where is the original proposal of the CM?
I have submitted, Your Lordship. Okay, I can give a fresh copy.
No. Just tell us. In October 9, 2007.
Yes, 9 October 2007. Lordship can go to page 11.
Page 11.
Item serial number 5.
Nongklau Ringi.
Yes.
How do you pronounce it?
Nongklau Ringi.
Nongklau Ringi.
Ringi.
Ringi. And who appears for the CM? Do you agree that this was your proposal?
Well,
Do you have a copy of your original proposal?
I don't have it with me, Malad, because at that point of time some other acting same was there, Malad. So the records are not with me, Malad.
Whether acting same or not,
The record
I can't absolve our responsibility by saying I was not Chief Justice in 2014 when this was done.
But the record is not available with the office of the same, Malad.
Now,
I can supply a copy at this stage.
The dispute falls within a small conspectus paragraph. The Khasi Hills Autonomous District Council passed a bill entitled the Khasi Hills Autonomous District (Appointment and Succession of CM, Deputy CM, Electors and Rangbashnong of Milliam CMship) Bill 2007. Upon receiving a formal suggestion in such regard from the office of the CM of Milliam, full stop. In the second schedule to the bill which was passed by the District Council, in respect of Sankur, Rayat Milliam, it was indicated that members from the following clans would form the electorate: Marbanyang, Sotun, Karkungor, Kurkalang, and Nongklau Ringi. Full stop. Paragraph. Upon the state endorsing the bill and notifying its publication, the enactment was published in the Gazette of Meghalaya on April 9, 2008 as notification dated November 26, 2007. Full stop. In the second schedule to the Gazette publication, in respect of Sankur Red Milliam, the name of the fifth of the clans was indicated only as Nongklao and not Nongklao Ringi, both within quotations, as had been passed by the District Council. Full stop. Accordingly, paragraph, by a letter dated May 15, 2017, the Secretary to the District Council wrote to the Undersecretary in the District Council Affairs Department of the state to the effect that there were discrepancies appearing in Schedule 2 II of the Act, open quote example, then single quote Nongklao, close quote, instead of single quote Nongklao Ingi, and open quote Sankur, red medium, appearing twice in the said schedule at serial 1 and 42, full stop, close quote. Upon the state government noticing the obvious mistake, paragraph, a corrigendum was issued on July 11, 2017, that was published in the Official Gazette on July 13, 2017. Full stop. Paragraph 14 of the relevant publication provided for the word Ringi being added after the word Nongklao, both within quotation marks. Full stop. The other change that was brought about by the relevant paragraph is not material for the present purpose. Full stop. Paragraph. It appears that subsequent to the publication of the said corrigendum, the Executive Committee of the District Council met on December 20, 2011 and took a resolution to recall the corrigendum that was published in the Extraordinary Gazette on July 13, 2017. Full stop. Upon the matter being referred to the state, the corrigendum was withdrawn. Paragraph. The District Council now submits that the recalling of the corrigendum was erroneous, as there was, indeed a mistake in the original Gazette notification published by the state, as the relevant clan in question was indicated in the bill as passed by the District Council to be Nongklao Ringi and not only Nongklao. Full stop. For such purpose, the District Council has carried a letter dated October October 9, a copy of a letter dated October 9, 2007, issued by the then Same of William, enclosing and forwarding a draft bill by the name of the Khasi Hills Autonomous District appointment and succession of CM, Deputy CM, electors and headmen of William Sameship closed Act, 2007. Full stop. Schedule 2 II capital of the proposed bill as amended to the CM's letter referred to the fifth clan as Nongklau Ringi and not only as Nongklau. Paragraph. Thus, the district council asserts that since the matter pertained to a suggestion by the CM of William, the district council, in its wisdom, accepted the suggestion in its entirety insofar as clan Nongklau Ngi was concerned, and there was an obvious typographical mistake made in the original Gazette notification, where the fifth clan in respect of Sanbar Red William was indicated to be Nongklau and not Nongklau Ringi. Full stop. Paragraph. On behalf of Mr. Pal, you have the respondent number?
I am respondent number 5.
On behalf of the respondent number 5,
6 minutes.
6, it is submitted that it was never the intention of the CM to include Nongklau Ringi and the withdrawal of the collegium has been rightly done. Full stop. Paragraph. The CM of William is represented, but advocate cannot confirm whether the letter dated October 9, 2007 and the suggested bill appended thereto were the original documents sent by the CM of William. Full stop. Paragraph. What is plain to see is that the CM of William suggested certain rules to be put in place, and the Autonomous District Council agreed with the same and put the rules in place. Full stop. If, during the process, what is the previous sentence?
What is plain to see is that the CM of William suggested certain rules to be put in place.
So if, now not if. On the basis of the material carried by the district council, it appears that there was indeed a mistake in the word Ringi being left out of Nongklau Ringi, which was corrected. Full stop. In such circumstances, the district council says that there was no basis to the corrigendum to the initial publication in the official gazette being withdrawn. Full stop. Since neither the CM of William nor you're the fourth respondent. You're the fourth respondent, Mr. Pal. Now the sixth respondent can immediately confirm whether the copy of the document appended to the letter dated October 9, 2007 issued by the CM of William How does this sentence go? Whether the copy?
Since neither the scheme of William nor the sixth respondent can immediately...
Last is genuine. And whether the original draft bill as suggested by the CM included the name of the fifth clan pertaining to Sanbar Raid William to be non-cloud or non-cloud ringy. Full stop.
If I may, let's disturb your lordships for a second. I apologize, there is a letter. I'm grateful to my learned senior to show me the records, the original records. Three dates become very relevant. The act was passed, the original act was passed in 2009.
Yes.
The corrigendum came into effect in 2017. There is a letter issued by the same of William in the original records. This is dated the 8th of September 2011.
Yes.
Post the original publication, before the corrigendum, where there is a request made that these certain portions should be corrected. Insofar as non-cloud, an addition of the word non-cloud ringy is concerned, is not there in this letter, which might have some bearing to whatever is the adjudication by your lordship. I just wanted to point out, if your lordship kindly peruse, this is the original file of the district council.
I have the original proposal.
So the CM did not suggest the change.
CM does not seem to suggest that ringy should be there. Because he has, it's a detailed letter saying that please add a comma, please.
Ringy was already published. No, ringy was not published.
Not published. So he doesn't say, insert ringy. That there is a mistake, please insert ringy. That is why this letter is of some relevance.
It is of some relevance.
I was grateful, my learned.
No, naturally. Records have to be seen. We have to go by records.
Lordship, I kindly just examine this one letter. Yes. This is a detailed letter. They say we need amendment to so-and-so section, so-and-so section, so-and-so section. But insofar as that schedule is concerned, there is no request. Which would lend some credence to what is being filed on affidavit on behalf of the same of William. That was not the original purpose.
But your original is produced.
Yes. If I may.
Very well, very well. It is pointed out on behalf of the respondent number 6 that the records produced by the district council reveal a letter dated
8 September 2011.
September 8, 2011, issued by the CM of William, seeking certain corrections being carried out in the act that was notified in the year 2009. Full stop. It is pointed out on behalf of the sixth respondent that those several changes were suggested in such letter, there was no reference to Nauklau Ringi being incorporated in place of Nauklau as was published in the original Gazette notification. Full stop. Paragraph. In the light of the District Council producing a photocopy of the CM's letter of October 9, 2007 and the suggested bill appended thereto indicating non-clau ringi and not only non-clau, comma, it is difficult to accept that both the original proposal of October 9, 2007 and the subsequent letter of September
11th, 8 September 2011.
September 8, 2011 can coexist. Full stop. The same and the District Council will clarify such aspect in independent affidavits to be filed within a week from date. Full stop. The matter will appear 10 days hence. Full stop. It will also be open to the petitioner, the appellant, and the sixth respondent to produce any material that may throw any light on the matter. Yes.
Your Lordships have already dictated the order. Non-clau ringi millets is a certain womb of the non-clau clan.
I remember that from previous.
Your Lordships have indicated in the order who are the other 4 people who are there. Is the Marbanyang millets, the Kharkungor, the Kurkalang. So these are clans millets. Now, Kharkungor also has 5 wombs. Similarly, millets, Kurkalang also has wombs. Now, what essentially happens if ringi comes in millets, that only one womb of that particular clan becomes a voter. And the Mintri of the Sema Millims Dorbar millets comes from that particular womb. So the rest of the non-clau clan gets left out of the entire process. Which is why I submitted before Lordship that it cannot be the intention of the legislature that what has been continuing since 1957 at time immemorial, they've brought on a letter on record that it was always non-clau, and all of a sudden it was decided that only one womb of that clan should be the.
No, but how did the CM suggest non-clau ringi?
Well, there is a spate of civil litigation insofar as between non-clau and non-clau ringi as to who should come in. What they have not disclosed is there was a suit filed, suit withdrawn.
Continue merrily. Without these things, how will we survive?
Matter the wisdom whether ringis would be there or not, that is, in my humble submission, not
relevant in the present context.
If it's not there, no?
It will become only when a decision is taken, ringis should be there or should not be there, that will arise. Today we are on the procedure.
I would humbly submit to your Lordships that the District Council in its wisdom did not incorporate the word ringi. The act which was passed, and we have the records here before your Lordships, which is signed by the chairman, show that it was only non-clau.
I'll file an affidavit.
Once the District Council files an affidavit.
In several areas we found that something has been signed in the evening and retracted in the morning, or something quite opposite has been signed in the morning.
As is the case here, Your
Lordship, this matter I seek
depending on the flavor of the day.
I seek a longer time, Lordship, at least 2 weeks time.
Very well, 2 weeks.
I'll have to call for the anyway.
Highly obliged.
Nothing is left out, no?
आपका ही है सर, आपको ओरिजिनल रिकॉर्ड्स आपको दे दिए। थैंकफुली आप हमको रिकॉर्ड
चोरी कर दिया था।
थैंकफुली आप आपको रिकॉर्ड दिखा दिया। आप तो खत्म कर दिया था केवल।